go ahead and call to order the Raymore Charter Review Commission meeting for May 2nd, 2017, and ask for a confirmation of quorum.
Commissioners Wilson,
Present.
Ackland,
Present.
Burke,
Present.
Castleman,
Present.
Wiggins absent, Hubach,
Yes.
Stidham,
Present.
Daring absent, Moorhead.
Present. We do have a quorum. Please stand for the pledge. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'll entertain a motion to dispose of the April 18th commission minutes.
So moved. Second.
We have a motion and a second. Any discussion? Seeing none, all in favor? Passes unanimously. Moving on to unfinished business, we have under Article 9, Section 9.4, City Council Wards. We had some earlier discussion regarding, I know, redistricting as well as some issues, so I'll ask for a report from Mr. Zerk.
I will only give a very short report on this. Back when you were discussing Section 9.4, City Council Wards, there was some discussion that came up regarding what happens if a redistricting causes a council member to be living outside of their district. Gave you a little bit of information, and at least in one city example where they said redistricting by itself will not disqualify you from your continued term as a council member. You would be able to then fill out the remainder of your term. There's language within the charter section, if you recall early on, which talks about the council being the judges for determining their own qualifications. If you were so inclined, you could consider the notion here of making sure that the council doesn't consider that particular item as one of the qualifications by simply inserting language that would say board, commission members, and council members who may be displaced by alteration of district boundaries shall serve the remainder of their terms. That's one route you could take with it. You could take another route, obviously, and I'm happy to discuss those with you. It might very well be making a determination that no, we're going to remain with the qualifications and letting the council make the determination on who is qualified as a council member or not. Though I would caution that presents some potential for, if you're not in our club or you're not in the club, that you exclude those individuals. So I present that to you under Section 9.4. We had discussion about it even in the last meeting. And somehow we got beyond it without any further follow-up and vote on it. We wanted to make sure and draw you back to it because it had been an area of interest for you. So that's the extent of my staff report. I'm happy to provide any additional answers or questions you have.
Based on the staff report, we're technically having open discussion on this, even though we don't have a motion. So does anybody have any thoughts or comments regarding the staff report, or do we feel that we need to pursue this in detail?
I think that you should, if you are on a board, commission, or any kind of a group aside from the city council, if you're displaced because of rezoning, I think you should be able to finish your term. I think you're there as a volunteer. You came on as a volunteer. Let them finish.
You need to speak into the microphone, all of you, so that I can hear it. When you got your back to me, it's hard to hear.
Okay.
Thank you. I don't want to miss anything.
I know.
Any additional thoughts
That made my day.
other than that?
I'm sorry.
Mr. Castleman?
Yeah, I agree with Tim because the other boards and commissions essentially operate treating people at large anyway. I've never, well, there was one issue that was limited to my ward, and everything else, and that it pressed across the city because we had the same thing, the linear park questions. But the question of linear parks applied similarly, equally to all parts of the city. We weren't looking to take or see an advantage to one ward or another. Many times it was based on availability of land, routes of development, and so the review of most questions were at large across the board and applies to the entire city.
Okay. Yeah, my thought on this as I was kind of mulling it over before tonight was, theoretically, when the council and the mayor appoints and approves people, it is still kind of still serving at the whim of the council. So theoretically, a person can, on a volunteer can be removed. But at the same time, I think there is kind of a spirit of, we intend for you to fill a term. And, I mean, I would hate to tell volunteers, we're gonna let you in the door until we decide not to, which I think is somewhat disrespectful. And so customarily, I think as a gesture of respect, because of how they volunteer, I saw merit in the fact of maybe, Mr. Zur, would you mind putting some sample language together for us to address the next meeting? If we are able to get through all the articles, we're gonna be going back anyway, so could you prepare some?
Sure.
You had spoken some sample language.
So let me, for clarification purposes, I heard boards and commissions, are we considering that separate from council, or council, boards, and commissions, all three will continue the remainder of their term?
Yes.
So that's the language we're looking for. I will make that provision, we'll present it next time.
One thing I do want to say on that though, before we close this topic, I'm, for the sake of future discussion, I would like to consider maybe the council separate from that. The council is chosen by voters. They may take a different approach, and we may want to explore that a little differently. While volunteers are really a subdivision of the council and governed by the council. And so there is a little distinction there. Maybe it's not enough that we do keep it separate, but I just kind of want to put that thought out there. When we go back to that, we may want to look into that from that standpoint. All right. Thank you for that. Does anybody have any additional comments regarding this section? Seeing none, we'll move on to new business. Article 11, financial procedures. This one's a little more bogged down, and there is a certain irony that the expert of the financial procedures is unavailable tonight for a legitimate reason. But in light of that, I know Mr. Zur and even the mayor can speak some on this. Does anybody have any issues of concern under this article or any sections? I've had the chance to play with this article for 5 years now, and sitting through a lot of Saturday, very long recitations of our budget, which honestly, Mr. Fearborn is excited through the entire process and loves every minute of this. I will say, as a person who also participates with the budget of our county, this article is applied so much better than any other entity I participate with. It's very clear, succinct, not only in its definitions, but in its application. Mr. Fearborn does a fine job. I hope whoever, be it Ms. Watson or anyone else who would kind of follow up with that would kind of follow by example. So, Mr. Sidham.
I'm just wondering, is this something that for the next 10 years will be a work in progress? I mean, this is the one thing in this that I can see vacillating back and forth. Is everything here hard and fast, or do we change that based on income, revenues, things like that?
Processes and procedures regarding the establishment of the budget changing based upon increased amount of income and revenue to the city, is that the question?
Kind of, yeah.
Okay. At this particular point, it would be more based upon, alterations I would see more based upon type of city that we are. We are a charter city at this particular point. That's controlled by certain statutory provisions as compared with cities of the third class, second class, fourth class, that type of thing. So I would suggest that as long as we remain a charter city, most of this will be continued on as it is right now in terms of this, regardless of, hey, we've increased our budget. If we increase our budget, we would simply be adding additional line items to it based upon additional revenues coming in.
Yeah, that's one of the things I was referring to, and this is just basically for my information. I was just curious.
Sure. As the city grows, so will the budget, obviously. Though I think it can still fit within the parameters of a charter city budget and this charter.
Some of this, especially section 11.4 under the capital program, some of these things, there are government principles at play that the law kind of sets out the general accepted procedures on things, and that's typically what is followed, and this is consistent with that. I don't expect to see wholesale changes. That you would almost see changes nationwide more. For example, Sarbanes-Oxley, after, our financial issues that we had in the late 2000s, where there's a large federal reporting standard change, that may affect how things are reported. But the general nature of how the budget's done, our fiscal year determination, our capital program, those things are kind of set. What we do within it is where we see the broad application. And you mentioned large growth, where we could see, for example, our county here we operate on, and Mr. Zara, I'm not sure, do we have, is it 3 primary funds or 2?
At county level? Or
At city level,
with the
sorry,
city
did I say
level?
county? I
Yeah.
apologize.
It's all right.
At the county level, we have 47 different independent funds. Here, I believe Mr. Fairborn said we have a primary operating, and then we have a couple of proprietary funds.
I think the district has 4 by law.
Yeah, so even if we grew, there is a format to adjust within general accepted accounting principles to adapt to that. I'm not sure that would necessarily be in conflict with this. Mr. Burke?
One of the things that I have seen work very well is as changes happen within a fiscal year, whether it be within management's direction or personnel or emergency situations, we have always made changes and amendments to the budget where we have taken money from one section that maybe was budgeted but wasn't going to be entirely spent, and then moved that into spaces where to pay for an unexpected expenditure. And it seems to me, from before from the outside and then now from inside more, I feel like I understand where the money is going better than when I've tried to understand other organizations.
If you look on 11.7, some of that is at play.
Exactly.
And so you'll see, for example, when we adopt a budget is allowed to be changed. Missouri statute, I deal with on a county level what the county limitations are, but we are allowed to have our own. 11.7 is probably the most used, and when you see on our meeting by meeting changes, this is where the city manager will come before us and say, for example, at the end of our fiscal cycle, we have undesignated reserve left over. Is there anything you'd like to do? Basically, and we've had instances, for example, where, for example, there was a budget for driver's ed, or additional training for law enforcement. So we've had some small ones. Our Centerview building that we're looking at, we had 3 years where we took part of that and moved it to a restricted fund to pay for that. And many people don't realize, with the exception of some of the exterior costs for like landscaping, that was already prepaid. So the bond money, almost none of the general obligation bond from our previous bond went to that. That was just to finish selected things.
And also some pad
The
bridges.
purchase of the land around Municipal Circle, to complete the purchase, we were able to reacquire some property much cheaper than we even sold it. And so that undesignated reserve was used for that purpose. So there are those, but as you'll notice on subsection B, there can be instances where the city manager has come before us to say, we had a particular road project, it was budgeted for X, it's gonna fall $7,000 short, and then if you'll read at the end, the council should then take such further action to prevent or minimize any deficiency, and that's where we are able to of course, it's through recommendation by city manager, he'll recommend, we have this unused money in this other budget item, would you approve moving it over? so you'll see transfers of appropriations, things like that. So that's what, you see all our boring stuff we do during the meeting, that is 11.7. You know, that we use that basically every meeting almost. And that guides a lot of our conduct. 11.8, tax rates and tax rolls. Ms. Hubach, you've been very outspoken on this one annually, because you have requested to lower our debt service levy and increase our park levy.
Well, I thought I wasn't gonna speak up much tonight, let you get through the meeting and let you see that. What I was going to say first, before I get involved in this, that it's my understanding that the budget is not set in concrete or stone. It is just a direction that we want to go, and so that we can make changes as we go along, and that's what we do. We may decide to change it this coming year. The council may decide that instead of spending the money on something X, they might want to spend it on Y and Z, and they've got that right, and I think that's true. Now, when you're talking about the tax rates, that's where I am concerned about. I think we ought to increase the tax rate for the park department. We get all of this land, we get it all developed, and yet we have no maintenance. There's a difference between the two of them in what you get to use the land for, and then who's gonna pay for the maintenance of it. And so I would like to see us take a look and see if we can increase somehow or other on this, increase what we spend on park and recreation. If you'll notice on all of our programs that we have, everybody seems to be in favor of anything that we do on the parks. So I don't think it would have trouble passing on our maintenance, because you can't take care of a park if you don't have some kind of maintenance problem.
Well, Ms. Warner, if I could kind of bring you into this, because you're actually mentioned in this section. Do we vote on the tax levies in August? Do you remember which month it's slightly off the budget cycle. But it's like we do it like a month or two prior to the end of the fiscal year. But the council actually once a year votes to do this. Now, I don't recall the last time we've had a change in the levy. I think we keep renewing the exact same rates and have.
Last year you maintained, I don't have prior years to that one. And the language of your current charter simply says that you have to do it by the statutory deadline. So in essence, you could probably do it before, but I think you're probably setting the levy based upon what the budgeted amounts are, as well. There's some degree of that as well from, in the process of, okay, we've got to make this much, do we need to adjust our levy this year in order to do so?
And Ms. Hubach, to aid your comment, if I remember the staff report the night of our last levy discussion, we are not fully at maximum level of our park levy. Meaning, the council has the ability to increase the park levy assessment without going to the voters. The voters actually approved a higher amount, we just haven't got there yet.
And I wanna know why. I wanna know why we're not spending the maximum amount available to us for our park and recreation, because people really care about that. And I think that the amount of money that we're saving is not really a savings.
Fair enough. And I know most of that discussion's actually for the work session that we have on this and the council vote, not necessarily charter review. Kind of bringing this up was just to demonstrate, for such a stale reading of a section, this is a very applicable section for the day-to-day operations of what you see the council do and what the staff does. Same with the sale of bonds. I know that we issued the last bond that was voted on. We issued the last bonds, or put them out, just last month for the parks. And that's where we're gonna fund the park-approved portion. So we do that regularly, so we have done that. And there will be some additional discussion. I know the park board had communicated to me that there was going to be some collateral things that need to be done as they're doing the main functions that we're voting on. And maybe that's a good time for a discussion on increasing that.
Well, I just think that we need to do the maximum, because if people if the voters have given us the authority to do it, why aren't we exercising it? Why is it that we're not making as much on the parks as we can? We need some more land, we need some more development. We're only 50% of our city is developed, and so that means we need some more land, you know, for parks. We don't have any big park in Ward 1 at all. We were supposed to, the deans didn't leave any, but Owen Good did with all of their development, and I'd like to see us start increasing the use of the land and the use of increase in the use of the money to make that land available. We've got a new, some land that's been donated in Ward 1, and the park officers, they're not gonna do anything about it because they haven't got the money and the resources, and so far they don't know exactly how they wanna use it. Let's get busy and do it. We need to have some thinking about this, and I see that.
Well, and the land she's referring to is, we're talking about extending Johnston Drive over to Dean Avenue. And a part of some development that's been platted there, platted for some parkland.
Well, I just think we need to have some vision.
Well, I tell you what, let's employ that vision onto, are we done with section 11? Thank you for the indulgence to kind of talk about that just a little bit. Moving on to Article 12, franchises. Any discussion on section 12? I'm not hearing any discussion. I think, are we wishing to move along? Okay, fair enough. Article 13, licensing, taxation, regulation of businesses.
Wait, excuse me a minute before
Yes.
you go to that.
Please.
I remember we didn't go any further on our meeting last time because Mr. Berg said he hadn't had a chance to study on franchises. So was there something on franchises that was a concern to you?
Actually, I hadn't read the last 3 sections in a while, and then when I did, I felt like that I owed the rest of you an apology that we didn't keep pushing that night.
Well,
So there it is.
apology
Regular
accepted.
Sorry.
Okay, then.
All right, moving on to Article 13. Mr. Zur, I know I'm not asking for a staff report on this, but just as a clarification or affirmation, the topic this year, especially for the ordinance review and the code review, is there may be some significant changes regarding our licensing and our regulation of businesses. But for the sake of the charter, 13.1 is basically an all-encompassing kind of a omnibus paragraph that pretty much just says, we're gonna set rules.
So the city establishes for occupational licenses, business license, occupation business license, and liquor licensing. All of those are outlined within the terms of the code in relatively detailed provisions. Chairman Moorhead is exactly correct in that 13.1 is a catch-all language that simply says anything that we identify for licensing purposes that are allowed by statute, we can hereby pass ordinances and license here in the state of Missouri. We can't trump Missouri statutory provisions for their licensing, but we can add to it based upon whatever authority has been granted to the municipalities.
Is everybody comfortable with, just one of the few times I can say I think it's pretty darn short word. Can't say it any better. All right, moving on to Article 14. Now, we do have some things here in the general provisions that may be up for discussion or worthy today. Section 14.1, personal financial interest. Mr. Zur, I know that the state periodically has, under the Missouri Ethics Commission, requirements. Again, I didn't ask for a staff report before then, but Are you aware of any major issues that may need to be subsequently reviewed on this?
Chapter 105 of the revised statutes in Missouri has specific provisions within it for interest for elected officials and what they can do as an elected official and for a 1-year period of time after they are an elected official. This would cover most of those, any elected or appointed officer, employee, or member of any committee, which basically is a restriction governing you can't come back in and do business and utilize your close contacts with the city in order to make sure that you benefit yourself, your family members, or your personal businesses. I don't have anything marked under 14.1 at this particular point, mostly because I'm going to refer outside of this to Chapter 105 in the revised statutes in Missouri.
Okay.
But I'm happy to talk about any provision of it that you've got questions about.
No, any questions for him on that? Under 14.2, I actually did develop a question under prohibitions. One of the concerns that I've had is we really don't have a very good ethics section regarding council. We've kind of talked about that in the past. But I look under subsection A2, false reports. Mr. Zur, is it possible that this section could also apply to sitting council members? As it talks about false statements, things regard to any test, certification, or appointment under the personnel provisions, but it does say, or in any manner commit any fraud preventing the impartial execution of such provisions, rules, and regulations. So if a council member, for example, failed to disclose a financial dealing, a conflict of interest.
This entire chapter, or this entire article, addresses elected or appointed officers, council members, mayor, employees, or members of any committee, authority, board, or commission of the city. So as far as I'm concerned, I would view that as being applicable to any of those categories of individuals as they work with the city.
Mr. Burke?
Does the term willfully, is that similar to language that would say knowingly, like such in the provisions on discharge of firearms, knowingly discharging is willingly, similar language to that?
I think that's very similar language. I don't know if I've seen as a term of art distinctions made between willful and knowingly at the end of the day. I guess I'd look to the other attorney in the
Is
room if
one more
you are aware
forceful
of
than the
case
other,
law
or?
that identifies a distinction, willfully and knowingly. I think a lot of times those are cited directly in the statutes and in ordinances, so it would say any person who willfully or knowingly, and they kind of do
So
it
they
as
can-
a single catch-all with it. I don't know if I've seen it made as a distinction.
I know that there are 4 primary levels of culpability. And when you're looking, you're looking at negligence, recklessness, knowledge, or intent. Willfulness is a word that is used in the law, but I'm with Mr. Zur. No one's, I don't think, ever uniformly identified exactly where willful falls. I would almost go so far as using plain meaning rule to say willful at least demonstrates that you had some awareness or participation, but I don't think it
Excuse me.
some court probably has defined it. I'm unaware of the exact level.
If I'm looking to, for example, United States Department of Justice, their language they've talked about for knowingly requires only that the defendant acted with knowledge of the falsity. So knowledge that you were making a false statement was justified. So I'm not seeing a distinction.
So are you recommending maybe change the word to knowingly?
I'm just wanting to know if that's what that word, if it has a special level of meaning.
So,
I don't.
sorry, reading down further through, there's a reference to a Fifth Circuit case, United States versus Liechtenstein, which says the government may prove that a false statement was made knowingly and willfully by offering evidence that defendants acted deliberately. We can't count that as a willful act, and with knowledge that the representation was false. So I guess there could be an identifiable distinction.
So
Deliberate act and
Yeah.
knowledge of the act.
Mr. Councilman?
Would that go so far to include an intentional act, because an intentional act is a stronger activity than willful activity?
Well, like I said, if you're looking like at the model penal code, to have knowledge and have intent are two different things.
Okay.
So intentional is meant to be a higher severity than just merely having knowledge. I get to blissfully at this point say I'm not the attorney in the room and shove this off, but this does bring up a very interesting point, because if we are ever looking at enforcement of a prohibition, we kind of want to have our words down before we start throwing accusations or charges. The other problem here is, in many instances, many people think of fraud and they think of criminal fraud. There's also civil fraud. So the act here may not be criminal, but still could be actionable administratively as a civil action. And therefore the definition, we were at one point, we're talking about culpability. Well, culpability is a criminal concept. It's not the same definite standard under civil.
If you added knowingly to it, so if you made it say no person shall willfully and knowingly, you're basically adding an additional burden for anyone to prove that, yes, in fact, you did commit such a false statement, incorrect reports, et cetera, et cetera. So you'd be increasing the level of burden it would take for council members amongst themselves or amongst the city in order to be able to prove that there was some bad act that had been conducted. Does that make sense?
Yes, I was thinking, let's say, in a moment of impassioned speech, somebody says hundreds or thousands instead of 100 or 1,000, and they accidentally say thousands, and I had this conversation with people. I'm like, well, your words have real meaning. You need to be careful with what you say before you say it in council, because it could cost the taxpayers money if you say something that's not accurate. And so you have to slow down and really be careful especially with numbers. I know I sometimes have a terrible time estimating numbers in my head in the middle of a meeting. And I think having that in there when the intent is not to be, not to commit a falsehood, where it's just a simple error in terms. I don't know how that works. I don't have enough background in the law.
I think we're doing it, I think the term willfully suggests you've made a decision at some point. Willfully have backed off, well, I'm finally going to do this. An intentional act, your plan is clear, that's what I'm going with. We've thought about it, but the act is clear. Willfully, you may have waffled a bit, and could include an error.
But I definitely think if there is an intent to commit any kind of a falsehood to, in any way, influence something, that needs to be done harshly, like as full as we could go.
As somebody who has been accused of being a liar on the dais in the past by another council member, it's very harsh to be accused of stuff like this. The irony is the person that accused me turned out their statement was false. Not the accusation of being a liar, but what they accused me, I turned out to be right, but it's uncivil to accuse somebody and to start throwing these around. I would hesitate to want to change the section here
Right.
to make it such a low bar that this becomes a sword instead of a shield.
I agree.
Now, we also want to be careful because at the federal level, our federal system recognizes what's called the speech and debate clause out of the U.S. Constitution, where if you're a federal legislator and you're on the floor of the House or the Senate, you cannot be prosecuted for your statements. The problem is we've seen in some instances, people make some really outrageous, heinous, blasphemous, insulting, and almost fraudulent statements on the floor because they know they can't be punished for it. And so I would not want to I would not want to create an instance where we possess that ability, because then Monday nights, while the newspapers would start showing up more, because we'd be a lot more interesting for our meetings, but I don't, so I want to be careful, you know, I think we should be careful how we dance around this. I like the idea of a better definition, but I'm not sure I want to inflate this section too much that it draws too much attention.
I just wanted to make sure that that word meant the same thing that I felt it did, and I feel like that I agree with the intent that you are saying is in the words here.
But should we add, I mean, we understand it based on our discussion, but the idea of our commission is to say, 5 years from now, if none of us live here in Raymore, the next batch of people are 10 years,
So we
you know
can
what I mean?
put the
Should
word
we
knowingly.
offer a word that is more like to say deliberate or no, even knowing?
You could potentially look at the prospect of willfully and knowingly incorporating that, because that appears to have been, at least in my very quick review, and I apologize for having to do it this way, it's at least been referenced to some degree of terms of art, so willfully and knowingly has been identified for judicial purposes in the criminal field.
I have a question, because I've actually been involved in something like this. When I was on the council and another council member was on there, every time I went to speak either for or against the project, he would always come up and say, well, Mrs. Hubach has lied again, and this is what it is. He was every time I spoke on anything, he always said that Mrs. Hubach has lied again. And people would ask me, why don't you challenge him? And I'd say, why? Just give him a chance to talk more and more. But what was bothersome most to me was not that he attacked me, but was that the rest of the council sat silent and did nothing. They didn't call him to order for saying, prove it, or let it go, what it is. And that bothered me, that the council did not protect one of its own.
Okay,
Because my shoulders were broad and I could handle what anybody wants to say about me. I've been in public office too long to know that you're gonna escape being vilified. But it was, like I said, it bothered me that the council as a whole did not support their fellow council members. And I think there should be something in here about it to give them the either authority or to suggest that they might want to do that. Because when I spoke, I had done my research and I knew exactly what I was talking about. But to constantly have to know that when you opened your mouth to speak on an issue, there was always going to be someone to say, but you're lying, you're lying, you're lying. And I've been there, and I can tell you it's not fun. It lasted 2 years until he got off the council.
well, then that kind of feeds the idea of making this provision be more of a shield than a sword. I'll entertain, does anyone wish to extend a motion to change the language of that to make it willful and willfully and knowingly?
Willfully and knowingly.
Question,
Yes.
what's the legal definition, current legal definition of willfully and knowingly?
So-
The mayor will probably remember, one of the struggles of the court martial manual was what was the meaning of deportment. There was an article that got a lot of guys some time, and they always argue about what did that mean? From a sneer to language, from attitude, what do you put a guy in jail for deportment? It was a catch-all phrase, classic military catch-all phrase, but it was never really defined.
Mr. Mayor, thoughts?
You know, we've kind of bantered those terms around on, even in the law enforcement realm as well, willfully and knowingly and lawfully or unlawfully. So if you were to include that in there, how would it read?
It would read, no person shall willfully and knowingly make any false statement, certificate, mark, rating, or report, etc.
Yeah, I mean, I think for purposes of law, and you can ask Mr. Zur about it, but I think that those two terms would actually be very helpful in any kind of censorship that might occur after the fact, because they, in fact, I think it'd be easy to prove whether they knowingly or, what's the other term I'm already forgetting? Willfully, yeah.
So,
Yeah, I think you could use those. So I know you've been doing research over there while we were talking.
sorry, Mayor. Yeah, I think if I were going to put it for thesaurus purposes, government may prove that a false statement was made knowingly and willfully, so two separate items, by offering evidence that defendants acted deliberately. So deliberately would be your synonym for your willful language. And with knowledge that the representation was false would be with your knowingly portion of it. So they'd have to prove two items, not just that it was false, but you knew it was false and you still made the statement.
Sure.
Well, one of the things that I did was, he put it in, some of it in writing, and addressed it to me, and so I turned it over to the city attorney, to Mr. Willard, for him to take, in case he needed to take care of. And so if there's something that you wanna add to that, I think it would be worthwhile, because I didn't know what else to do. Nobody stood up for me, nobody said anything, says what, my word against his, I guess, and then, but like I said, I turned over, it was scurrilous, the letter that he wrote, and I turned it over to the city attorney. So, but whether you need to have something like that in the charter, I don't know. But we were just seeing things getting worse and worse. It's coming down from Washington, and once it gets to Washington, it doesn't take long to get to Raymore.
Right on. Mr. Zur, again, I apologize, I should have asked for you to be prepared with staff reports on this. Looking at the editor's note on at the bottom of 14.2, I was not on the council regarding the issue of concealed weapons or weapons in chambers. I mean, I remember some of the political drama of it, and I don't necessarily think we have to rehash that, but is the editor's note relevant for us, since it mentions a committee to amend the charter and the vote? Is this to imply we are to change 14.2A4?
That is to imply that the language you have in there is what was approved by
Got it.
that vote in November of 2010.
Mr. Stowe?
As you can see, I've got this highlighted in here. A lot of it is because of the language. Missouri is now an open carry, lawful, and we've got carry any concealed weapon, and then it goes on to explain that can do damage too. So are we saying that we can't conceal it if we walk in the door? Can we wear it on our hip if we're permitted? How should we go with this?
I think that is a decision, I think that's probably a decision that needs to wait until your next meeting. I do know that there is a file that we have maintained with regard to this provision. We are an open carry right now, but I know that we also have the ability to institute rules on our side with regard to concealed carry provisions in city and municipal offices.
Are we an open carry in here right now? Oh,
Mr. Chairman,
Yes.
what, I helped carry that petition, and what,
There's no
what was
prohibition in
behind
City Hall
it
yet.
was the fact that the people in the audience could not carry a weapon into city council chambers.
Yes.
But the city council members could, and people said, no, we don't want it that way. If the council can carry weapons into City Hall, we want that right. And the council at the time said, no, you can't carry a weapon in the City Hall, but we want the right to do it. And the people said no, so I don't know how you want to, whether what the state is doing about open and concealed and everything, whether that has any reference to here. But what we were after was, we were saying there's not two types of citizenship. We all carry or none of us carry in City Hall.
Fair enough.
Doesn't the new provision though say that there are structures that you're forbidden, quote, or
We could-
in government buildings is?
We could impose
a prohibition.
prohibitions within the city if we were so inclined to do so. So the question I would present to you as a commission would be, if you all have a preference one way or the other. Yes, we want to be able to do open, yes, we want to be able to do concealed, yes, no, we don't want to do either of them, no, we don't want to have one or the other. I'm happy to go back at this point and make sure that it complies with what state law currently is and make a recommendation for you the next go-around. And that might well be, you have proposed to me that you would like to see this in there, that is not allowed or that is allowed based upon our current state law. And I can work my way down through those, but I would foresee at least 4 or 5 options. Yes, both, yes, one or the other, no both, no one or the other.
Didn't they make a requirement that as far as the courts are concerned, you cannot carry in the court? So that one of the things that we had to be able to do then for Judge Nairo and all is to have a place that is where they cannot carry weapons. They have to
Okay.
be safe.
This, to me, big picture, I think we have addressed this in other ways. The tax issue, as far as tax arrearage on candidates, is a prime example, where the state has state preemption. They control. We can pass any law as long as it is not inconsistent with state law. So in this particular instance, when the voters voted statewide to allow open carry, basically, we can have this in there, but state law controls. Do we need to put language in here that basically says that this section is governed by whatever the state code says, or state law says, which means, let's say 3 years from now, state of Missouri decides to flip back the other direction, then we don't have to keep coming back and saying, are we consistent or not? Because we're just saying, we should be consistent with whatever the state law is. And then if we wish to put known exceptions in there, we do that independently to say, fine, we're gonna abide by whatever state law says. My understanding, interpretation is, we have open carry and concealed carry, meaning
Correct.
right now, the state says we can walk around, but the state law also says, unless you independently designate something as off limits, that's what we should be focusing on. Not trying to figure out whether we're consistent. We should just embrace state law and then choose to say, except for instances when court is in session in our courtroom, or, and carve out those. My problem with this, and I actually had a question about this, I was asked to issue an opinion when this was up for election the last time, because when you use the definition of they can carry, you can't carry on any building owned, leased, or controlled by the city of Raymore. And the problem with that interpretation is, since our city codes department can determine whether you have the ability to have occupancy in your house, and our South Metro Fire can determine whether a business can open or close, technically every single dwelling in the state of Raymore meets that definition, which means the city can keep you from having a gun in your house. I thought the ordinance was bad in the beginning. I just didn't say anything about it, but when asked about that, I actually pointed out our language infers way too much when you use the phrase to control. So,
What direction do you want me to have?
I will open this up for, do you guys wish to have staff give us a more focused explanation? We're already asking Mr. Zer to wing it on a few topics tonight. This one's complicated enough. And because I believe we're gonna finish with our articles tonight. We have 2 meetings after this before we need to go to the council. This could be a perfect discussion for our next meeting where we have significant time to beg through that. Would anybody be open for that, Mr.
We're
Stitter?
still gonna go through the other, with the other issues on this yellow sheet, right?
Yes, but I want to give Mr. Zer the opportunity to give us some proposed language.
Well, what's the direction?
What are you looking
Yes.
for? What are you looking for?
Thoughts?
Consistent with the RSMO.
Mr.
I
Burton?
look at section B just right after it, and it makes me feel like my question earlier in number 2, where it talked about willingly. Well, here we have under penalties of breaking any one of these prohibitions is willingly violates. And when talking about concealed weapons, with even our confusion about the new state laws, it would be very hard to penalize someone when it would be confusing, possibly even if we have it posted. I don't know that
Okay.
I'm providing a direction, but,
Well, no,
but
well-
it's interesting because, well, if they're willingly violating it, they thought, well, oh, isn't this, to know all the different,
Would you feel comfortable,
Levels.
since Mr. Stidham is saying that the general focus should be a recognition of state law, whatever the existing state law is, and if you don't mind, Mr. Stidham, for me to kind of assume what you're, work with the, we start with the state law, but we have the ability to exempt.
Sure.
Does that click, would that offer enough clarification? Because it takes
we want
section
it, we want it to
A4
not
out.
be difficult for people to comply with the law. We want it to be easy to understand what the intent of the law is, so people can comply with it.
Mr. Wilson?
I think, I'm not sure on this, but I've read the new ordinance several times because we've had this issue about where I'm employed at. And just the mere, just merely posting a sign on the front door of City Hall with a gun with the X through the mark through it is not sufficient enough to have someone arrested if they violate it.
You're correct.
There are ongoing circumstances that have to be involved. So the merely the chief or whoever the officer might be that's attending City Hall meetings, council meetings, does not necessarily mean that they're gonna arrest someone that we find in violation of the law, of the ordinance. So if that intent is to be able to prosecute or arrest or remove them, then we need to look at some other issues, I think.
Mr. Zimmer?
So are you looking, and I think you're right on that, I guess what I'm looking for is, are you looking for language on my side that says, we as the city adopt state law, but if available to do so, have prohibition language within it that says, we are adopting state law, and if allowed, adopting prohibition that says no concealed carry, no open carry, or any of those things within the terms of the language? Or are you just looking for, here's the state law, you guys can choose between open carry, concealed carry, or neither?
My thought is we do consistent with state law, but the exceptions are based upon, if by a vote of the council creates basically an exemption zone or a building or an event, that the council by majority vote can create an exception as long as it doesn't violate state law.
One-time event, one-time location, or are we talking, we can establish,
Terms and conditions
One
to the,
location.
so, consistent with state law, but if council is able to pass an ordinance that says, okay, we've decided no open or concealed carry anywhere in City Hall, period, end of story, unless you're a commissioned police officer, we do that. Is that
are you guys comfortable with that?
I am.
I'm
comfortable
Mr.
with that.
Stidham?
One of the complications that we had before when I was police chief and we were bantering this idea around was that liability insurance carriers will require that if you put the prohibition on a door, there has to be some kind of assurance for those who aren't carriers to ensure that the carriers aren't getting through those doors. And so it requires some form of metal detecting and that type of thing. So that, we didn't want to go to the expense of that equipment. And so if you can't guarantee a prohibition, you set yourself up as a municipality for failure if something were to happen and that person hadn't been checked appropriately, as is done down at the courthouse where they walk through the magnetometer. So keep that in mind too, that it creates some liability on our part if we put that prohibition sign on the door and don't really enforce it to its fullest extent. And so that's why I think we went with Joe Willer's opinion, they carry, if they don't, they don't. I mean, we took the signs off the doors.
Mr. Stidham, I'll.
And we have security in the
next.
room.
But I wanna say, but do we not still, by just creating the council's ability to create the exempt areas, everything you're saying is completely valid, but that would be more at the level of the council. For example, if the council wishes to put all those liability issues in place, that's a factor they would have to determine and consider if and when
That's
they
true.
wanted to treat the exemption.
That's true.
We're creating more of the outer fence rather than what's inside the fence to say state law, but we do possess the ability to create an exemption if need be.
So it may be, from a liability standpoint, appropriate if you're going to talk about doing a change to say, we adopt state law, but until some specific ordinance is passed, we continue to maintain a no concealed, no open carry, no concealed carry, like what you've got right here already. Hey, no person shall directly or indirectly carry any concealed weapon, blah, 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 but it requires an actual action by the council to change that one. So the notion would be you'd have to incorporate this language into your ordinances right now, so we don't have any interruption current, and then you could change your charter in order to be able to say, we will comply with state law.
Well, I understand what the direction, but I think you're adding in a factor of the presumption of no concealed weapons or concealed weapons. When I think the initial motion was state law with council's ability to create an exemption, but we're not creating what the precondition is. Mr. Stidham, you've been very patient.
So I'm listening to just the dialogue back and forth, but I also think too that, you know, we talk about not being able to supersede or single out something against the state law. And if the state says that you can carry concealed, open, on your hip, on the forehead, wherever you want to carry a stinking thing, I'm kind of, I don't know, I guess I'm questioning why we would even need 4 in here, other than to say, unless determined by the city council, we will abide with what the state has to say.
So your motion would be, can we simply delete 4 in this section and still be in compliance with state law?
Yes.
Well, we're governed by the 4 corners of the document, so if we remove it, by implication, we are saying whatever state law is, it is. The question, and my thought I wanted to still discuss was, do we wish to maintain at least some ability to create an exception to the rule, which would therefore be the only purpose for a different number 4. The only reason why, I guess I'll come kind of be brash about how I say this. Here's what I don't want to do. We had a lot of drama regarding this issue at multiple levels, at work sessions, at council votes. It went to the voters, they voted one way, the council came back and tried to circumvent that. Here's what I don't want to do. I don't want us to completely start over and redo that argument.
I agree.
But I also kind of want to respect the voters. And the voters initially said one thing, and now, of course, the voters have gone back and statewide and said something completely different. What I want to do is I want to get us 9 out of the, because I'll put it this way, most everything I see on our little amendments list, very little of it do I see being really controversial before any council. But we slapped this gun thing on there, and now all of a sudden, we are the hot button in the city again, and everybody's gonna be looking at the 9 of us going, were you guys not living here when you had the issue before? And so my thought was, I'd like to respect state law. I'd like us to make this not having to be looked at every time we look at it, to where we just say we honor state law. But if state law says we should have at least the ability, and as a lawyer, I'm a little biased, you should never let a gun in that room in the middle of a trial, I mean, or a courtroom. I mean, you know, there's a couple of places, even as a pro-gun guy, I'm at, you just don't take a gun into, I don't care how pro-gun you are. So should we not be able, see, I think what we voted on though recently, I think allows us to create exceptions. I don't think it's an absolute open carry or concealed. I think there is some small ability for us to keep that in some check, and I'd like us to just recognize that, but,
I think there's merit to everything you just said. Keep in mind, when this was bannered around the last time, the law was different, state law was
Yes.
different.
yes.
So we had nothing really to go in and pull out of our hip pocket or carry in our shirt pocket and say, here's what the law says, we do have the ability to do this.
Right.
So I think there's a huge difference now versus, and the voters statewide. I mean, it was a mandate, pretty much a mandate, that we would have open carry and we would have constitutional carry.
Right. Well, I see two issues here. Maybe if we break this out. One, does anybody here believe we should not use or have language, either one expressed to say we're gonna recognize whatever the current state law is, or as Mr. Sidham suggested, if we cut out our section 4 altogether.
I'm good with
we
either one of
default-
those.
Either way, we get recognition of state law. Is anybody really actually disputing that portion? The second portion is, do we add language that allows the city to be able to have the determination of an exemption?
Mr. Chairman,
Yes, sir.
that's what I'm leaning towards. I'm leaning toward, I don't want a weapon in the courtroom. There's places I just don't feel comfortable at either, having worked in courtrooms like that. Whatever the language says that you can have them, don't have them in certain places, but you can have them in other places. What is that language? That's what I'm leaning towards.
Okay.
It sounds like what exemption, that,
Yes.
is that kind of what I'm thinking? There are certain places I just do not want to win.
You shouldn't be allowed to have one at a Little League sporting event.
Well, I think there's a clause that says any sporting event that has they've established a certain attendance crowd figure that you're not allowed to carry those. Do you remember offhand some of the locations that have a prohibition now?
Circuit court, unless you're a police officer and you're identified as a commissioned officer. City Hall, I know City Hall in Kansas City, you're limited on that one. And the municipal court, which is a separate building in Kansas City as well. So all I can do is give it to you by examples of where I've seen the prohibitions placed. But I would note in each one at the municipal court in Kansas City, they do have the detectors set up in order to test each time anyone who walks through the door, which goes to the mayor's comments on that.
And they do have private security, and then they have law enforcement security
Yeah.
also.
Circuit court, city hall, as well as,
Federal.
Yeah.
Do we need to have a section because once again, we're looking at willingly again in the penalties. Do we need to have a part of the penalties talk about, okay, if they unknowingly violated number 4, whatever we decide on number 4, is there a component of it, if it wasn't willingly, that we have an education component? Like we did with, where we just basically, if it's so confusing between knowing what the state law is at the time and our local ordinance as well, we really need to have an education component. I don't know if that belongs in a charter or a city ordinance or resolution, that we have an education component of what these things are, because any one of these, if we can't penalize anyone if they didn't willingly do it.
Well, I tell you what, and Mr. Burr, I think you were going to suggest we add the same language we used in 4A as in 4B. So it's not just willing fully, it's willfully and knowingly. Would that cover what you want, or do you want to discuss a separate educational component?
I wonder how you can enforce something. A rule to me that is unenforced is not a useful rule, like a hat rule. If no one actually enforces a rule, then I know I'm talking about high school stuff, but if there's a rule where it's not really enforced, or like everyone when they come in needs to, if we had a prohibition, all people must turn off their cell phones before entering the city council chambers. Let's bring that and say there's a penalty, you can be asked to leave. But if it says willingly, doesn't, follow the prohibition, we would need to have a component to make people know what the law is, so they could later on be charged with knowingly doing it again. I know that's maybe,
Well, that was the component, is when
Crazy.
they dealt with the last vote, that was the reason for the posting of the sign with the, red circle and
Right.
stuff. Cause that gave you knowledge of a prohibition.
Right.
So, I'm not sure we need to have.
Okay.
Well, no, I'm not saying we don't need education, I'm saying, I don't think we need to go
it
through.
doesn't need to be in here.
Writing that maybe it would be an
Not something
ordinance
for
or something.
not something for the voters to approve in a charter change.
Not in a charter.
Yes.
But maybe, maybe there is a general provision at the very beginning that there needs to be something that says to require citizens or to allow citizens to have knowledge of what's in here. The city should provide on its website identifiers of what can and can't be done. There should be free samples of the charter put out for any public to pick up for free, to where they get access to information,
Or
things like
like
that.
A pamphlet that, as a person who, that maybe a meeting's going on and they realize that someone is in violation of something, and they say, hey, can you come outside and we'll talk to you, and you give them that piece and say, this is prohibited, you're not going to be penalized for it this time, here's some information.
Well, remember, you can't ask someone that's concealed weapon, you can't ask them if they're carrying concealed, that's against the law.
See, I don't understand most of this, of the state law as it
Ms.
is.
Hubach, I will say this, I'm actually, I'd like to look into that a little more. And the primary reason is this, I'm not sure the state has the ability to do that. Individually, I have the ability to do it. And the reason, just like with free speech, I was listening to a lecture on free speech this morning. A lot of people sometimes forget, you don't possess a right to free speech. The government may not infringe upon your speech. I, as an individual, can infringe upon your constitutional rights every day. Now, you may look at me and go, yeah, whatever, and dismiss me and disregard me, and that's your right too. Now, those are rights, but the government has a restriction. I believe what you're referring to is the government may not approach you on that, but individuals, I believe, can, especially on private property.
Okay, the reason I said that is, when the council discussed it, that was one of the things that they brought up. I think Mr. Cox brought it up, that we could not ask anybody if they were carrying concealed, if they had a carry concealed weapon or permit.
Right, and during a council meeting, that would be a state activity, even though it's a city, it's the people's. Backing up here, because I want to kind of I want to make sure we're giving Mr. Zur appropriate instruction for the next meeting. So it is our desire to seek language out that would replace section 4, that would merely reference that the city abides by whatever state law is,
Yet has the latitude to create
as long exemptions that are still consistent with state law.
Yes.
Recognize state law as it stands now, replacing current code or current charter provisions. Allow exemptions by ordinance for items such as courtroom, council, city hall, center view, acceptable, et cetera, if possible. Is that right?
Well, and Mr. Zur, I'll even allow, I think we're even kind of implying, you don't have to give examples. If you wish to, you can, but we're not requiring it. We're just wanting, we want to give you a broad enough stroke that you can offer the best language possible.
Got it?
Are we comfortable with that?
Could you say that again for me?
Yes, I want to give him the instruction to create language to replace number 4, that we will respect state law. And probably the better way to say is, if state law allows the city to create exemptions, the council has the ability to create exemptions. But offer no guidance beyond that, because then at the ordinance level, the council will then kind of regulate from there. And that also allows individuals, kind of the people, to have the ability to communicate through their representatives on more of this issue. I wanna pull us out of this issue.
And
as
within
much as
an
possible.
ordinance, there could be an educational component within an ordinance.
Well,
And that so that would not necessarily even need to be here either.
But I like the idea, Mr. Burke, if you don't mind, on section B, we still, to be consistent, to have willfully and knowingly included in that. And at our kind of when we go back and kind of look at the forest for the trees, I'm comfortable with us entertaining the idea of some educational component. Not a lecture, I mean, it can be anything, but here's the reason why. If many of you remember our discussions on Senate Bill 5 and all the changes to our courts, one of the specific things at the state level was every court is to hand out a sheet of paper explaining procedural rights of the defendant. That you have the right to talk to the prosecutor, you have the right to go in front of the judge, you have the right to ask for a continuance or reduction of bonds. And, prior to all that, my natural instinct, and maybe I see myself as flawed here, is I used to take the attitude of, if you're smart enough to do the crime, you're smart enough to know the rules of the crime. And I used to be kind of a little cynical about it, like, hey, you chose to do that. Until I really looked at those Senate rules and realized, you know what, it doesn't hurt anybody to educate a defendant a little better on where they're at. Handing somebody a sheet of paper doesn't hurt anybody. But I've had defendants stand in court, and not even my clients, where I've watched them going, oh, I wish I could go represent them because they are so clueless about this system. They're convicting themselves. And I really struggle morally and ethically on that issue. So the idea here is, well, this is not a criminal violation. I don't think there's anything wrong with us educating people, because it doesn't just educate you that you can't bring the gun in, but what about instances where it's completely appropriate to carry? Should they not receive the ability to be able to interpret the law, how to use their rights for their benefit, not just in limitation? So I like the educational
I would like
concept.
to know more, honestly, as a citizen, about laws, because that's something I've considered, whether that's something I want in my household. And I certainly want to be in compliance with the law, first and foremost, as well as safety. But I feel like I don't know enough as a citizen to make an informed decision on it. And that's something I'm going to have to work on.
All right, so anything further on 14.2? I didn't expect so much time, but Mr. Castleman,
Yeah,
yes.
the mayor brought up the issue about insurance, the liability
Yes.
questions about that. Is there any case law on a municipality being held potentially liable for failure to safeguard an environment?
Yes.
Because I think a lot of the interest in this question
Yes.
come from the Kirkwood incident, which was a,
Right.
There's that, but it even is more
can't
broad
think
than
of a
that.
good word to call it other than what it was.
Well, and there's even more kind of banal examples. For example, the county, Cass County paid out a large liability claim because of an individual. If you ever go down to the county, the steps leading into the building are not necessarily the most secure, and they've kind of crumbled and broken in some pieces. A gentleman fell, just tripped on a step, hit his head and died. And the county was held liable for creating an unsafe environment. So the definition of unsafe environment may be as extreme as Kirkwood, but it could also be as simple as bad sidewalks, steps, no hand railings.
Not
they're-
removing ice.
Yes, well, that's a
Is that different?
very
Okay.
delicate
All right,
issue.
all right. I
Up in
I'm sorry.
Kansas City. Well, because
Oh,
like
I
up in
didn't know there
Kansas
was-
City, there's different rules. The city charter in Kansas City is, if you have a sidewalk in front of your house, you are responsible and liable for it, and, for the sidewalk.
My father told me that's true in Independence as well, but I don't know that
Yes,
for sure.
but as we have pointed out numerous times, in Raymore,
It's
you are not.
Right.
In fact,
I was
we
surprised to
believe
learn.
case law is consistent to say, if you go and shovel the sidewalk, then you become liable.
Right.
You really should leave it alone. Because then you don't participate or interject yourself into the condition of the ground. But once you manipulate it, then you may create some possible liability. So,
Yeah,
that's,
I recall in my past employment background as in the insurance business, that was an issue about municipal exposure. I mean, Missouri is supposed to have municipal sovereignty.
Right.
That doesn't work out, you can't get sued, but you can, and very successfully. And there have been a number of attorneys who are trying to change the law on premises liability from a special relationship to a total relationship, that you're responsible for everything. And that was one of the issues in common areas in strip malls. If you have a common area passing your business, once you go out and shovel that, not the landlord, that's yours on into the future.
it's called supervening cause under causation principles. Okay, if we have nothing under 14.2, anything further, and liability could be addressed at a ordinance level. Political activity, I believe under penalties, we would want willfully and knowingly. So we would make that language change. I don't wanna, I wanna move a little quicker, but under political activity, I do wanna note, our existing charter does not limit or prohibit staff and city employees from participating. There are certain governments, you can't even put a yard sign out and support somebody. Raymore, we do allow it. Okay, 14.4, 5, any issues regarding those? 6, regarding official bonds. 14.7, charter amendment. Just so happens this relates to us.
My apologies.
No, you picked a good time. We're at 14.7 under charter amendment.
Derek, I have a
Yes.
question back on 14.5.
Please, sorry.
I've written something here to myself, regressing. After occurrence, I've written the term or manifestation, because occurrence may not manifest itself until a later date. Something could occur, but not evident at the moment of occurrence.
Mr. Zur, tort law, causation.
Yeah. So the manifestation of the occurrence, which you're suggesting could occur far down the line, is that what the notion is?
It's like the black lung cases where the occurrence is constant exposure to contaminants, but it doesn't manifest itself for 10 or 15 years later in your life.
I sure don't want to give any additional opportunity for people to sue the city of Raymore.
Yes. And that's what you're bringing up. Mr. Zur and I are over here going, I don't want to speak. I'm gonna let him say
As soon
it.
as the water main broke the other day, I've been coughing on it.
I have to be careful here because we're in the middle of an ongoing criminal charge. But our previous county auditor has been charged with receipt of stolen property while in office. And part of the reason why he wasn't just flat charged with stealing was because the state Supreme Court abolished part of the stealing statute. So this is how they were able to do this. Here's the dilemma. When you read in the paper that he stole $2,000, he didn't steal $2,000. He stole close to $12,000 with over 200 incidents more of theft. The problem is language like this, because here's the dilemma. He was in office 4 years. Also during that 4 years, his spouse was involved in the conduct. The problem is he's in the office that controls all the paperwork that provides the disclosure and discovery of his criminality. So At the end of his 4 years, when he is finally audited and discovered, and you go back and go, oh, you only have a 3-year statute of limitations, that meant the thief was able to successfully hide his theft and benefit from the hiding of the theft. And so the problem that we have here is, in certain instances, and you know, where there is an instance where like somebody slips and injures themselves, that can be a very defined occurrence. But for example, let's say there is a sexual harassment claim or something that is not so date defined, that there could be some more subjectivity of time there. And it could be, do we place a burden here where somebody, the city, and I don't want to pick on anybody in particular, but let's say a city employee does something. If they're able to hide their conduct for 91 days, should they benefit from that? It becomes very awkward. The problem I have though is while equity says, when I'm the plaintiff's attorney, I am totally wanting to see this go out. So it should be 90 days from the date of discovery of the occurrence. But then on the other side, as a current official, I'm going, oh, heck no. And I even want, if it happened at noon, I want the half day to count, you know what I mean? So you can see, depending on which vantage point you have, this is either a very strong provision or a very penalizing provision. But you bring up a very good discussion point.
Because of what the Missouri statute is still 5 years, as I recall, so.
Well, I can tell you the problem that you have there is there are numerous statutes where we have what are called fluid statute of limitations. For example, in Missouri, rape.
Yeah.
Rape, it is not a hard 5, or it is not a hard 3, or, I mean, there's up to 10 years. But in the rape statute, there is from a point of discovery.
Right.
Especially on child crimes. So if you have a child who is sexually assaulted, because the age of the child, that should not be a shield or a way to avoid. So it's very nebulous.
I am happy to do what this commission directs me to look into.
Yes, fair enough.
Is that an acceptable answer?
Sounds like we'll stick with occurrence, huh?
Well, I'm open to whatever the group wants to do. I guess I will politely say this. In law school, we spent several weeks just debating that concept. My fear is we could go this calendar year and not fully. You're bringing up a very, it's an iceberg.
Right.
We see the tip
Right.
and don't realize the base of the ice under the water here on that one. Mr. Burke?
Procedural question when this is over. Every time that we add, like say the phrase "and knowingly," is that going to be a separate vote? Or,
Yes.
so each time we add two words, it's gonna be another issue on the ballot?
Yes.
New version of the section.
Per section.
Per section?
Per section, yes.
Per section of the 12 or the 14, or of each part of each one?
Section 14.3, if you made multiple changes
We
within
suggest-
14.3.
Okay.
We suggested on point 3 as well.
I think there's a certain point where there can be fatigue
Well,
in
there can be, but Mr. Burke, one of the
But we do
things
need
we're
to be
gonna do
consistent.
when we kind of play our catch-up meeting, one of the things I would propose is, once we see these, if we look like people are gonna vote 13 times on the word "and knowingly," we can summarize that, put it in the definitional
Good.
section to say,
Okay, excellent.
anytime the word willfully is used, it is defined as to be willful, knowing, and deliberate.
That is
And that
excellent.
so there are ways, we will see how palatable our plate is after we
Very
see
good,
all
very
these
good.
components.
I appreciate that.
Does that address?
That sounds very good.
Okay, Mr. Castleman, I do not wish to steal your thunder though away on 4.5. Do you
Okay.
wish to discuss any further?
No, I just want to bring it up.
Okay. We are back on 14.7 charter amendment. That is the process of what we are doing. Does anybody have any concerns or complaints over what we've been doing? We technically have been living this process, so theoretically, if we did have problems, we would have discovered them through our application. Ms. Hubach, you look like you wish to express a point.
Yeah, we had some problems, remember, on the Charter Review Commission, on how they should be selected and all.
That is
That's
correct.
good.
And I just wanted to make sure that we did not overlook that area.
That's
I beg your pardon?
14.8.
The members shall be selected as provided by the council.
Let's go ahead then and move to 14.8 on that point.
If I may, Chairman.
Yes.
I did have one item to bring forth for commission
Oh,
consideration.
please.
Which is a trickle down from the changes made to 10.4.
Okay.
In this, it would be 14.7 subsection F, almost to the end of the paragraph, where it states that petitions shall comply with the requirements as outlined above within 5 business days. That was changed by motion and vote in 10.4 to 10 days. So this would be a trickle down for consistency purposes. I just wanted to bring that forth for commission discussion.
It's already been down, it just needs to be reprinted that way.
Well, technically no, because while it does state it in 10.4, since we don't reference application of 10.4, I'll make a motion that we change the number from 5 to 10.
I'll second that.
We have a motion, a second, any discussion? All in favor?
We would change what to, what was it we were
Tim, would
changing?
you point her to the specific,
Yes, on
a
that.
date, or time? Six lines from the
You were
bottom.
10, we're on 15 and you're back to 10, right?
10 was the number of days.
It was 14.2. Yeah.
I think you referenced section 10 too, maybe?
It's
Okay,
how long
you
does she
don't
have
have,
to-
Okay,
she's
alright.
got a different one, she doesn't have what I have here.
Oh,
Um,
now are you looking on subsection F?
There is no F.
Oh, you're looking at an old version, Ms. Hubach.
Is that an old one or
Yes.
like a?
Mr. Sorrell,
Can I help? 14.7 F, changing from 5 to 10.
That is the amount of time to certify, Ms. Hubach.
So change it to 10 days.
That is correct.
It's okay.
So, since we stopped the vote, and I did not fully officially count the vote, so we do have a motion and a second. All in favor? Passes unanimously. Thank you for that. Moving back to 14.8, Ms. Hubach, you were bringing up a point over how the members are selected.
Let's see here.
Now, if you look at the second full paragraph, I think that by plain meaning, the members of the Charter Review Commission shall be selected as provided by the council. And in our last instance, the council did a resolution and passed a resolution that laid out the terms and conditions of how they were selected. When that resolution was passed, that was an appropriate application of this charter.
We had a problem, remember, we said that there'd be 2 members from each center. And in Ward 3 only had 1 member, but we gave him a deadline, and we had to extend the deadline because there was nobody interested. So maybe we should take another look on whether we want to always have 2 people from each ward, if that's as important, or if it's the overall importance. Because we should not have had to extend time for 1 ward that we didn't extend to others. That we did, we had to make an exception because we wouldn't have enough people from Ward 3. And they finally brought Mr. Wiggins in there and he agreed to serve there. But he did not do it under the normal terms.
May I make a suggestion on interpretation, Ms. Hubach? this section, our charter actually says exactly what you just said. We don't have to have 2 members from each ward. The resolution that the council passed is what created that. And I believe that can be remedied in the next resolution, that they should just not include that. But the charter just merely says, not more than 3 of whom shall be elected of the city officials, and no more than 3 of the commission members shall reside in any one ward. Well, you could have
We could have.
technically
Right.
3 members in 3 wards
Uh-huh.
and leave out an entire ward by charter definition. So we don't need to change the charter. It already says exactly what you want to say. But now, the resolution that just got passed last year was not in violation of the charter. But if there was an error, it was an error in the resolution, not the charter. Do you feel
I would
that's
agree with
consistent?
that, yes.
Okay.
Is it nothing having to do with the gentleman that they finally decided he would be available?
Sure.
But it was that we made exceptions for everybody, I mean, for one person that we didn't make for anybody else.
Which did put
And
off,
that's not, I'm
which
not in favor of.
delayed the process.
exceptions.
It did in turn delay the process at least a week or 2,
Sure, sure.
which ended up for it was good.
Okay.
This time.
Is there anything in addition to 14.8 we need to add or delete?
Did you make a change to that?
We made none.
No.
14.9, public improvements, special assessments. These
Is
again
anything
are,
said in here, or
Yes,
does
ma'am.
it need to be said in here, about what the council can do with our proposals? When we do it as carrying a petition, they have to go exactly what we say, they can't make any changes. But when it is done by charter, by individuals as well as the city council, does that mean they have the right to make any changes? Or do they have to accept what we provide? It was my understanding that they could review it and they could add their own, the council could add to it if they wanted to, but they couldn't change what we had agreed upon.
Yeah, when it's the Charter Review Commission, there is some leeway there, because the council is going to have the opportunity to review your proposals and then make a final determination at that time. So it's different under the Charter Review Commission than under the procedure for certifying the petition. If you have a petition that gets certified for a change, that goes on the ballot based upon a certain number of members of the community who have signed off on that petition. I don't believe the council has the ability to make a determination or an alteration there.
are you comfortable with that?
So they can, if we decide to do something, they can't come in and change it. I'm just using as an example, suppose we put a term limit on there and we spelled out how we want to do term limits, and they said, no, they don't want to. Can they go ahead and override us?
Yes.
For your
Order.
With a
purposes.
vote of 5 to 8, if the 3 that were on the commission.
The
all
council
agreed.
shall recommend to the voters of the city proposed amendments. We are an advisory board of the council, so we may suggest term limits. The council members may vote no, or they may disregard. Technically, the council has the ability to nullify every single thing we do here. We are serving at the whim of the council.
And then technically.
And we're
we
just
would have
wasting our
wasted 9
time.
months.
Yes,
Correct.
other than the.
Other than the great discussion, the
Other than the
education that we
fact
have.
that we met the requirement
That's
of
true.
meeting and coming up with
That's true.
recommendations under 14.8. And it would be exceedingly short-sighted of a council not to at least accept some recognition of what this body has done. But I have to acknowledge that we have a broad spectrum of intelligence that has served this city. And I'm not inferring I'm one of the smart ones, but I'm just saying,
That's comforting.
Well,
I'm
just
being honest.
accept
I
that
mean,
70% of the passing score, if you get 70% of them through, then feel like you did good work.
Yes, but I would believe this current council would be very receptive to hearing the recommendations. There may be 1 or 2 amendments depending on I mean, that I'm unaware of going in. But but there have been more contentious councils, and potentially we could see, I mean, in a weird circumstance, somebody could just go, you know what, we've decided to do nothing, no changes. Weirder things could happen. Now, I think people would be upset after 9 people went out to the North Cass Herald and say, what do you think we've just done for the last 9 months? Take a look at all the YouTube videos to see our discussions, and that could be considered next April, at least for half, but,
I'm trying to think of when we had to notify the people what we were doing. And can that interrupt what it is the council wants done?
You are to.
Remember when we did some of the other charter amendments that, they had to be, once they were approved by this group, then they took them before the council and approved them, but they also took them before the citizens of the city and said, this is what we've come up with. And the citizens had a right to say, you know, how they felt about it.
14.8 simply indicates that the Charter Review Commission shall, within that time frame set, report to the voters as many of the amendments as the charter. So the report to the voters is going to be when you make your presentation to the council in front of the entirety of the city, much like the mayor would provide a state of the city address to the council, but he's doing so to the full of the voters. So that's the language you've got, is report to the voters. I'm sorry.
you did not interrupt, you're fine. Any other additional thoughts or comments regarding 14.8? I mean, I guess we're kind of discussing and validating our existence today, or at least the fact that we must be humble and may not exist depending on the level of the council, but.
They disappeared.
Yeah, exactly, but, and again, to clarify, I don't know if you guys were in the room, the discussion was, the requirement that was in the resolution of 2 members per ward. Technically, the charter does not speak to that issue, but the council possesses the ability to pass a resolution creating the construct of the charter commission. So if there was no violation of the charter when we fell short of a member in one of the wards and chose to kind of delay time to put somebody on there, but that's an operation of the ordinance, not the charter. So if anybody wishes to clean that up, that can be done by
Operation of the resolution, not the charter.
Yes,
Right.
that can be done at that stage next time. The charter itself is fine. Public improvement special assessments, we have the ability to do that. Proof of ordinance. Don't believe anybody's ever, Miss Warner, does anybody ever actually ask for a sealed stamped copy?
Yes.
That happens. And then separability, Mr. Zer and I know that to be defined as boilerplate. Ladies and gentlemen, we have finished our charter,
Okay?
and that ends new business. As to section 6, going over our status to date, we have, I believe, 2 regularly scheduled meetings before we are to present to the city council. So we have 2 meetings to go back and to discuss kind of cumulatively issues, either to raise anew, raise old, and rediscuss, or just affirm what we have kind of parceled out for review. I know Mr. Zer's gonna come back with some language regarding the concealed carry prohibition section, so we can get past that. And Ms. Hubach, I'm gonna recognize you, you have something in hand. What do you got?
Well, this is what, in 2008, this is what the commission came up with, and I was gonna ask, are we gonna come up with it, or are we expecting the council to come up with it?
That is governed by the council and how they wish to
So
communicate to
the
the
guide
voters.
to the voters and how we present it, because see, we have to give the justification. So it's up to us to provide the justification for each one of these things, if I understand it. Shall the section, whatever it is, and then it says, that's what the question is. Then we have to give the justification on all of this.
Yes.
So it'll take us at least 2 meetings to do all of that. And have we ever really discussed term limits?
We have spent probably the largest chunk of time on any individual section talking about term limits.
What did we decide?
No term limits.
No term limits on anything, okay.
I will project our next 2 meetings because of this, what Ms. Hubach mentions. Not only are we just kind of giving an additional second thumbs up or affirmation, we will need to look at what we have parceled out, make sure we understand ourselves, what the explanation of the change is for, things like that. Make sure Mr. Zer's additional language that we're gonna finish up. I would suspect we will run at least 2 hours both meetings. I mean, that will take a little bit of time. We've already agreed that we're gonna take whatever's time necessary to complete this project. I will say, in the quote, other section here, my personal comments, we ran a little quicker up front by doing 2 meetings a month, but we never had to go to more than 2 meetings a month. And I really want to applaud all the members because I think we've been pretty on a consistent path. I think we've gotten a lot done. And so I like what we've done. So these last 2 meetings, I think I probably run as smooth as the ones we've had run before. And I think we're at a position where I think we've got a good summary that staff has prepared for us, that we should at least have some guidance into that, so that'll be our new business to review. I think we're gonna hit our deadline. Mr. Stidham first, please.
What does June the 17th look like? Well, are we physically there presenting this to answer questions? With regards to you as the chairman, will you be on the dais? Will you be down with us? Mr. Burke, I'm just kind of looking to see what it looks like.
In this particular instance, because I'd actually contemplated that myself. One, I feel that especially since I was entrusted to serve as the chairman of this commission, I should not be on the dais, that I should stand with the commission. But I'm not necessarily of the belief that I should be the one to present. Because I am a member of the council as well. And while I appreciate my ability to kind of shepherd the room and procedurally, substantively, I welcome anybody standing and presenting. I think we've all contributed to this. I'm even open if we collaboratively present whatever would be most effective.
And will we present every proposed change?
Yep.
Did we ever,
Ms. Hubach.
I don't remember, and I haven't missed any meetings, but I don't remember, what did we decide on the conflict between the mayor making and breaking a tie, and where it says that the council, there has to be at least 5 members of the council approve any ordinance, especially where a contract is let. So, to me, if it doesn't have 5 members, it doesn't make any difference whether the mayor breaks a contract or not, breaks a tie or not.
Ms. Hubach, when we voted on that issue, it was an 8-1